You're Lamarian Bean
So,
in 24 CR 2413. Does he need to go before you?
That's already judged.
Earlier, you pleaded guilty in 24 CR 2413. That's aggravated assault with a deadly weapon. A pre-sentence report has now been prepared. The parties had an opportunity to review it as you were here with Mr. Brogan, your attorney.
Yes,
Are there
sir.
any corrections or changes to it?
Yes, sir.
Go ahead.
I believe it was misunderstanding on the part of communication between the probation officer and Mr. Bean on the first page under defendant's version. And it states on the pre-sentence report, I pleaded to it, but I know for a fact that I didn't do it. I got to take life hands. I got kids and I know I can do great. I believe the misunderstanding occurred was this particular offense, Your Honor. The plea was to an aggravated assault with the use or exhibition of a deadly weapon. The weapon was not fired, but there was no doubt that there was a deadly weapon. The deadly weapon this occurred in Mr. Bean's apartment. It was his gun. He purchased the gun legally. And so there's no doubt that the gun was there, but it was not discharged. And I think what he intended, but it got lost somewhere in the translation, was he did not intend to shoot anyone and did not discharge the gun. I believe that if you ask him in the court, I expect to probably ask him, he was guilty of the offense of aggravated assault. He also possessed a deadly weapon, hence a firearm, but he exhibited it. It was not one of these cases where he actually used it. The fact situation here is a court where it was his apartment. He came in, he broke the door to get into the apartment because it was locked. And the gun was there. There's no doubt about that. There's no doubt that he had the gun. The officers found the weapons. They found some bullets in the house. They weren't in the gun, but they were in the house. So none of that. He does not dispute it being a deadly weapon, but he does dispute him using the gun to threaten them by pointing it at him or anything like that. And I believe that is just a misunderstanding between him and Miss Roach. And he is guilty.
Of what?
He's guilty of threat.
Hold on. What he said and what you've said negates guilt.
Your Honor, I believe that the gun was there and he had the gun, but
The fact that it exists isn't a crime. It's what he did
he
with it.
exhibited it. In the indictment, it states if he exhibits a deadly weapon, then in there exhibit a deadly weapon to wit a firearm during the commission of said assault. And I believe that's what he pled guilty to.
No, that's not what it's, you're missing the most important part. He used it to threaten the lady in its use. To threaten her with imminent bodily injury. You want me to read it? That's the statute. Well, that's what, did then and there intentionally or knowingly threaten the victim with imminent bodily injury. And did then and there use or exhibit a deadly weapon during the commission of the said assault.
Yes, sir.
Well, what did he do?
He exhibited a deadly weapon.
It says, I pleaded to it, but I know for a fact I didn't do it. I got kids and I know I can do great. So he's not admitting guilt. It's placed on the trial docket. I don't accept the deal like that.
can I speak, sir?
I'm sorry, you said what you needed to say. We're going to put it on the trial docket. Do you want to continue to represent him, or we can get to trial quicker if you agree to release him? But there's no hedging being done in this court. You're speaking over the court. You'll have a chance to speak in a minute.
It's what you talk. If you want to.
Do you want to Are you gonna continue to represent him?
Judge, I can represent him. I believe the fact though was that he did exhibit a deadly weapon. It
That's
was
not a
there
crime.
and-
It's the way it was used.
But I think.
By threatening. By threat, he threatened another person. I don't have to read the statute. You know what it says.
Sir, I understand,
But his first words, I pleaded to it, but I know for the fact I didn't do it. He's talking about the indictment. It's not a question. He doesn't admit.
But
Next.
Again, Your
All right,
Honor.
what are we gonna do?
I'm sorry.
Do you
I'm
want to
sorry, I
represent him or not?
apologize. I'll continue. I believe that when he exhibited a deadly weapon that committed the incident.
All right, it's gonna be set for trial. I mean, I'm not gonna, I can't tell you that on that.
Judge, let me talk to.
No, sir. What are we gonna
Ask
do?
him if he wants
We
to-
got other things to do. It's set for the trial docket. Do you want to represent him or does somebody else?
Are you on?
I will represent him, but I don't know if he wants me to represent him.
He can represent you. It'll probably get to trial quicker if you agree to release him. What do you want? And he's appointed. So
Yes,
you
sir.
want him to
Judge,
continue to represent you? I can replace him with someone on the trial docket wheel and get this to trial pretty quick.
Please, sir.
That's what we want to do.
All right, so thank you.
Find a good cause to replace and it will
Yes,
go to trial. Next is what? John Allen.
Yes, sir.
John Allen, please. Who's on that?
Mr. Allen does need to swear in front of the environment.